Hey there, this is Nick Zagar and Remy Isdaner. We are Mirlo Real Estate Partners. Welcome to the Denteligentsia podcast, where we help dentists answer any business questions with lots of different guests. Today we have Dan Schulte from Kerr Russell. He is an attorney who is very knowledgeable and can be very helpful for our dental clients who have any legal matters on the horizon. Welcome, Dan. How are you?
Doing well. Thank you. Thanks for having.
Absolutely. We're excited to have you here because you, facilitate one of the biggest roles that a lot of our clients deal with, uh, you know, when they're, our process, a lot of times it's a lease negotiation or negotiating a purchase agreement, but also advising them on a high level. What's important? What should they be concerned about? We're really excited to have you here so we can really ask you some questions, get some good tips and guidance. Welcome.
We love talking about happy stories in general, because who doesn't love a happy story? But sometimes the best stories to tell are the scary ones, so that you know what not to do. And I think, piggybacking on Nick's comment about how important the role of an attorney is in our projects in general. I mean, I don't think we can overstate that. And so often these conversations include sharing those scary stories so that you make the right decision.
Well, I guess to kick off, why don't you tell us a little bit about yourself and lead into some of your favorite client stories?
Well, as you said, I'm an attorney. I've been with Kerr Russell my entire career. I started here in 1992. I guess that's 30 some years. Doesn't seem like it's been that long. Seems like a lot longer than it actually has been. I've done a lot of different things over the years. Primarily what I do at this juncture of my career is what I would just describe as transactional work. I don't go to court, and that's by design. When I first started out, I thought I wanted to be a trial lawyer. It didn't take me long actually doing that to realize that I just wasn't wired the right way to be happy doing that sort of thing long term. So I got into transactional work, buying, selling businesses, real estate, setting up businesses, taking businesses apart. That involves a whole lot of different things: employment agreements, shareholder agreements, leasing work, anything involving a contract. Basically, most of my clients are in the healthcare arena, one way or another. Dentists, group practices, surgery centers. I've been primarily responsible for my firm's representation of the Michigan Dental Association and Michigan State Medical Society and Michigan Osteopathic Association. So represent a great deal of healthcare professionals and a wide variety of transactional kinds of things. Buying and selling practices is a large part of, the horror stories you mentioned. I think the biggest mistake a dentist, a physician can make when buying or selling a practice, and I say this with a little bit of trepidation, because I'm dealing with YouTube brokers, practice brokers here on this webcast. So I'm sure you wouldn't do this, but I think the most important thing a dentist can do at the outset is to assemble a team, and that includes a lawyer, an accountant, your real estate broker, your practice broker. You can't forget about the insurance professionals. Sometimes you have one agent for everything. You may have separate agents for both malpractice and for just general commercial liability, workers' comp, and all of the other coverages that you need to have if you're going to own and operate a business. I think the mistake that is made is that brokers are engaged to go out and find the practice, or to go out and find the buyer for the practice. And brokers that's their role. And I think it's important to understand what everybody's role is in the process and what it is not. Once the building is located, practice or the buyer is located, that's the broker's role. There are a number of brokers out there that, have purchase agreements and other documents that they'll sort of throw on the table and tell their client, the dentist, that you either don't need an attorney at all, or just have your attorney take a look at these things and sort of rubber stamp what's in them, but it's sort of billed as a money and time saver to their client, the dentist. And in my experience, nothing could be further from the truth. It's penny wise and pound foolish to not involve your attorney, your accountant, your insurance people, and other professionals at the outset. If you try to wait to approach a closing without using these professionals and then bring them in at the 11th hour, where all they're going to do is say, what about this? What about that? Do you know what this paragraph means? What that section means? Was this negotiated? Was that negotiated? What about the purchase price allocation? What about the indemnity? And what about a holdback? And what about all these contracts? Are they assignable? Are they not? All of the things that an accountant, a lawyer is going to want to make sure that if they're not discussed until the very end, when everybody at that point thinks they're ready to close, and you find out that you're miles from being ready to close, it just leads to a lot of discontent, a lot of frustration, and sort of going back to the beginning, and you've now wasted a lot of time, and it leads to a lot of frustration and a
Dan,
lot of necessary problems.
I'm gonna just add a quick PSA, and I'm gonna help reinforce some of your main point there. To any real estate brokers out there using their own legal documents, don't do it ever. And to any clients who have brokers who are providing them with legal documents, find a new broker. Call us, call someone else. So we couldn't agree more. And the message of spending money now, the right type of money, in other words, penny wise and pound foolish, it's a conversation we have with our clients all the time, because these projects are so expensive to begin with. And so they're always looking for ways to save money. But there's ways to save money the right way and ways to save money the wrong way. And when it comes to counsel and hiring an attorney, it's one of the more serious conversations we have. It's not the time that's not the opportunity to save money. We'll save it in other areas. That is going to protect you indefinitely in the case of a purchase, and for the next 7, 10, 12 years, and really beyond, based on your lease and so forth. So we can appreciate that very much. And I'll say one more thing about this. There are stigmas out there. There are industry specific stigmas. And I think attorneys have them, real estate brokers have them. And to borrow a word from my 7-year-old, a lot of us suck at our job. We know you don't, and we don't either, but there are a lot of us out there doing things the wrong way. So we appreciate those cautionary tales and best practices and bad practices, because we're having the same conversations with our clients every day.
Every deal has its own road, but in a perfect world, you wanna set a solid foundation and build a good and strong team so that you can have the right information to make the most informed and best decisions, whichever way the road travels, so to speak. And so, I mean, certainly as commercial real estate brokers, we can likely lose our license by practicing law because we have no, we're not accredited to practice law. We can, we're licensed to help negotiate business points and that lead into a purchase agreement and help set you up for success, or also, the business points that feed into a lease document. But as far as the actual negotiating of legal points, it's a big no-no, and it's a scary place to be, and I would never do it.
Can we take a step back for a second, and can you talk to us about how you got involved? How did you get involved in the healthcare space and working with doctors? Because it's such a niche. We share that with you, and we have our own story, but it would be nice to hear yours and how it got started.
Well, here at Kerr Russell, we're a full service law for 50 some attorneys, and we handle just about any kind of legal matter you can think of. The healthcare space is something that Kerr Russell has been in for a very, very long time. Just to give you an idea, the firm celebrated its 150th anniversary this year. So we've been around a very, very long time, and our representation of the Dental Association and the Osteopathic Association and the Medical Society goes back decades. So healthcare has always been a large part of what we do here at Kerr Russell. And as a much younger attorney, as I said initially, I thought I wanted to do something totally different. I wanted to go to court. It took me about a year and a half of doing so to figure that it's not like it is on TV, and I certainly wasn't cut out for it. In a former life before I went to law school, I still am. Was a CPA, so I had a pretty strong business background. I practiced public accounting for a few years before I went to law school. So just understanding business and financials and tax returns and doing the transactional work kind of was the natural next step for me. And I think that kind of, gave me a leg up in putting deals together, just, understanding the tax and the financial aspects of how these businesses are run. And there are some very interesting the fraud and abuse laws, all of the licensing laws, the surgery centers, the Stark law, the anti-kickback statute. There are a number of specialized healthcare laws. It's really a business unlike any other that you have to take into consideration in structuring transactions as well, and knowing what to look out for. That you layer that on top of kind of just the general business and tax concerns that go into any deal. Made it interesting.
I mean, those unique considerations are a place to go next. So for a dentist looking to start up or to acquire an existing practice, what are some of the common legal pitfalls that they should be aware of, or things that they can look out for to protect themselves?
Well, I think, Nick and I were talking about this earlier. When dentists, certainly new grads, very few new dentists are going to graduate and look to buy a practice right away, if that ever happens. I think in most cases, dentists coming out of dental school are looking to be employed by some initiative. So step one is the employment. And there usually aren't any brokers involved in going to work for an employer, but there is an employer with an employment agreement. And again, it's penny wise and pound foolish not to have an attorney review that employment agreement, and an attorney experienced not only in healthcare law but in dentistry in particular. People that understand the different compensation methodologies, people that understand covenant not to compete law, people that understand licensing law and regulation, that are all part of negotiating an employment agreement with the healthcare professional.
Yeah, our favorite clients are these early career dentists, and so this is really important stuff for them to understand. say that I just graduated and I am I got an offer and I hire you to review my employee agreement. What are the big things that or what are the that you see that I should really be mindful about? Or what are some of the craziest things that you've seen that you've helped straighten out for your clients?
Well, I think the biggest consideration for most dentists, and usually within the first three sentences, they will ask, what do you think about the compensation? Is this competitive? Should I be getting more? And no doubt, compensation is important, right? I mean, nobody wants to be the one person that signed up for 10% less than everybody else in the area is making. But I think that is probably the least of the concerns for the new dentist, because you pretty much know, you talk to your classmates, you get a pretty good idea what everybody's making, and know if what you're getting is reasonable. Couple of other things that are overlooked that I think are very important are the term and termination provisions. Number one, many times in the terms section, it'll say that, it's an employment agreement's going to commence on the effective date, the date that it's signed, and it's going to continue for 3 years. And people think they have a 3-year contract. Well, nobody has a 3-year contract. Bill Belichick, Jim Harbaugh, people like that have contracts that are of a fixed term, right? And they're going to get paid no matter what for that time period. No dentist has such an arrangement. More important than the term section is the termination section. And every single employment agreement says that it can be terminated without cause. You just have to give a certain number of days notice, 30, 60, 90 usually. And a for cause termination section, the difference being if it's for cause, it can be terminated immediately. There is no notice period. And the for cause termination events should be limited to you lost your license to practice dentistry, your DEA registration was revoked, your controlled substances license was revoked for some reason, you set fire to the building, you stole all the petty cash, those types of things are for cause for immediate termination. But in most cases, it's going to be the without cause notice period. And if it's 30 days, what you have is a 30-day contract, and you need to look at it. Other things about term and termination, the for-cause termination should go both ways. The dentist should have the right to terminate for cause. And what would that cause be? Well, you don't get paid what you're supposed to get paid, when you're supposed to get paid. There's no reason you should have to give notice and continue working for the without cause 30-day notice without getting paid on time and the right of, or be provided the benefits that you're supposed to be provided. So that's a big misunderstanding of what the term is, and not having a for cause right of termination.
Do you find that the termination provision, is it merely an education opportunity where you're having a conversation, educating the doctor about it so that they're aware of it, how it works, and plan accordingly? Or is there wiggle room? Do you see success in modifying that to be more favorable for the doctor?
So on that point, because this is a common mistake people make too, that, I was told, this was a standard document.
Mm-hmm.
Another favorite thing that employers will say is, well, I've hired 3 other people, they all signed it, so, you should too. And probably my favorite is, well, my lawyer has already looked at this, so, you can get a lawyer if you want, but,
you don't have to.
Yeah, right. And they think, as if that lawyer is also working for you, the employee, when they're in fact doing the exact opposite. They're writing this so that it benefits the employer, but there is a balance that needs to be struck And maybe the other three people can't read or didn't want to take the time to read it, or um, were too cheap to hire a lawyer and just kind of took whatever it's, who knows? None of that is a substitute for actually understanding everything that is in this agreement that you're signing, even if it isn't at the end of the day totally to your liking. And it won't be. The sign of a good deal is when everybody walks away a little bit unhappy. That probably means that it's down the middle, it's fair. But you've got to understand exactly what you're getting into. Another example of this is the covenant not to compete. Every dental employment agreement is going to have. It's very rare that there is not. The FTC a year or more ago at this point, sent out a rule banning covenants not to compete in this context. That's all on hold due to subsequent court rulings. Covenants not to compete remain enforceable in Michigan, and they will for the foreseeable future. The issue is the covenant breached as to time? 2 years is the maximum anybody should be asking for. As to the geographic scope, that depends on where the patients of the practice are and where they come from. It shouldn't be any larger than where these patients reside. The penalties that we see sometimes, if you breach the covenant, say it's a single patient that you see within the restricted area, if there's a liquidated damages provision that says, you owe me $50,000 for every single patient that you treat within the restricted area, even if it's a $150 cleaning that you missed out on, all of these types of things are unreasonable. What I always tell my clients is, if you go back to your employer and ask that these unreasonable things be taken out and they refuse to do it, that's a window into the soul of your potential employer. That tells you something about who it is you're signing up. And if they're going to act like this at the outset, when they're trying to be courting, they want to hire you, what are they going to act like once you sign and you've got no leverage at all? It tells you something about the people you're about to go into business.
Yeah.
For us, it's that scenario plays out with landlords and our clients leasing, right? It's, when someone behaves in such a way that, when there are red flags and we're still in the courting process and a landlord is looking to entice a prospective tenant to come into their building, and there are already concerns, and that's before our tenant, our clients, bound by a lease contract. It's
that it does have a term,
that does have a term. Yeah, it's not a reason to abandon the opportunity altogether, but it certainly raises concerns about the person that you're going to ultimately, enter into an agreement with in a relationship for the next 7, 10, or 12 years.
Yeah, I mean, that actually speaks to part of our process, is that we want to be able to find 3 or 4 viable options for our clients, so that they may have one spot that is, by and large their top choice, but until they go through and negotiate on multiple spaces, they don't really know the market. It's an opportunity for us to kind of and get to know that landlord and see what kind of landlord they are, because this has to be a happy marriage, because likely in these leases we sign 10 or 12-year leases quite a bit with renewal options. And so this is that dentist's career. They'll be there 20 years potentially. And so it's got to be the right fit. And it's good to kind of find that stuff out on the front end, so you can course correct if you have to.
Right.
We actually, on the non-compete side, typically we're seeing it as opposed to, grabbing a patient from within. They can't start a practice from, with it. It has to be 5 miles or some, arbitrary number from the practice where they have an associateship. And so I don't know how often you see those. What's typical? I mean, we see 5, 10 miles.
We saw 10 in the metro area recently. I mean, it's unthinkable.
And 10 miles covers a lot of ground. I mean, if you live on the east side of Detroit and that's where your non-compete is, you're going to be driving to the west side.
Right.
So, I mean, it can be.
Well, what in what the law says on this subject is that it can only be as broad as it needs to be to protect a legitimate business interest of the employer. And I think the easiest way to define what that legitimate business interest is, as I said, is where did the patients come from? If you plot out on a map, every address of your patients and say a 5-mile radius is big enough to encompass all of those pins on the map, then 5 miles is probably reasonable. If it's 7.5, 10, 20, I don't know how you justify that. People are not, in most places, are not driving 20 miles and passing every dental office along the way to come and see you. So
Yeah.
it's just not reasonable to think you need that to protect your practice, because you're not getting those patients 20 miles away.
I mean, even in a reasonably suburban area, you're likely in that 5 miles, you're likely going to pass 20 dental offices.
Right.
I don't know if there's any other legal pitfalls that you want to talk about for these inside of these associateships, or we can kind of switch gears and talk a little bit more about leasing.
Well, before we leave the subject of covenants not to compete, another big item for me anyway, when I'm reviewing these contracts, is to make sure there are reasonable exceptions in the covenant not to compete. And the biggest is what I call the short-term termination exception. So if you start with an employer and say within the first year, you're just not getting along, it isn't what you thought it was going to be. And this can go both ways, right? I mean, it could be the employer decides you are not who they thought you were, or things are just not working out. You can just kind of tell when it's not. If you've only been there a year or less, you are no competitive threat leaving the practice because you haven't seen the patients enough to establish any kind of a relationship with them that you're going to be able to make use of if you leave. Even if you open it, you go next door. So there ought to be an out from the covenant not to compete if there's a termination, especially if it's the employer that terminates the employee for no reason. And it happens relatively quickly, say within the first year, that the covenant should not apply at all. That is something you'll very rarely find in a first draft in an employment agreement coming from an employer. And you got to hire a lawyer who does this routinely.
That's a great point. So now we're talking about a scenario of I'm a new dentist. I'm doing a startup, and I hired Remy, and he showed me a bunch of places, and we got a lease, and we give it to you, Dan.
Well, first things first, the economic terms, and this is where you guys come in, and I would rely on your judgment. Is the term, is the rent, is it triple net, is the landlord paying the expenses, all of the dollars and cents aspects of it, is that market? That's the first question. Presumably it is, or you wouldn't be, suggesting that your client enter into. What I think most people that haven't leased space before, common misconception is a lease. And you mentioned this before, Nick. Unlike most other contracts, there is no without cause termination. in a lease. You sign a 10-year lease. That is a promise to pay rent and expenses if that's the deal in the lease for a 10-year period. It is more like a loan transaction than it is. Many people sign leases, say they're, a third, halfway through the term, and who knows why, but they want out of the lease for whatever reason. And it's only then that they realize that they are on the hook for the rent, even if their business fails. It doesn't matter. You have an obligation to pay the balance of the rent for the balance of the term, no matter what. So I always have that conversation with people up front. You got to make sure that your business can sustain this term, that this is a location, it's the right size building, you've got room to grow if you need to, that you're going to be happy here for the term, because like it or not, you're going to have to pay this rent for the term. Part and parcel of that is the assignment and subletting clauses in the lease, which is something I don't think enough attention gets paid to. That may be your only exit if you have a problem and you want to get out of it. And you need to make sure there's reasonable language in the assignment and subletting clauses that will enable you, at least that will give you the possibility, if you no longer want this space, you can find somebody who does, and they'll continue to pay the rent so you don't have to. And that includes language. If it's a dental office and you want to assign the lease or sublet to another dentist that has been in business, the same period of time that you have been, that has financials that are similar to yours, that the landlord shouldn't be able to prevent you from doing so. Landlord consent is always going to be required. That's not unreasonable, but they shouldn't be able to unreasonably withhold their consent to an assignment or subletting if it's a tenant for the same use that has the same financial wherewithal that somebody stepping into your shoes that's very similar.
Can I interject real quick? This actually comes up quite a bit, and it's actually a really challenging one, because 9 out of 10 landlords will say, "Oh yeah, sure, if the the entity or the person that you're assigning to has equal or greater financials." Well, when you're 65 years old and you're selling to your associate, or you're selling to a young dentist, likely they don't have the same financial wherewithal as somebody who is entering the twilight of their career. And so can be a challenge. Do you have any strategies or, ways you've worked around situations like that?
Right. So whether or not you are going to remain live then becomes the issue, right? So in an assignment, typically you would be out of the equation. Lease would be assigned to a new tenant. It's just the new tenant that has the obligation to continue paying the rent. On a sublease, not so, right? I mean, you're going to have a sublease with somebody else. You remain on the hook. That subtenant, the new dentist, doesn't pay the rent, then you're liable. You remain liable for the rent. So in a situation like you just mentioned, the old retiring dentist sort of acts as a guarantor, new dentist's obligation to continue paying, and that's how that works. So it would be a subletting arrangement or an assignment with a guarantee.
The original guarantee stays with the stays.
Yeah, we try to we incorporate assignment subletting and recapture into our engagement letters, our letters of intent, LOIs or RFPs at the onset, so that the hope is by the time it gets to your desk, it's already been softened. But again, it's a critical topic. It's a critical concept to plan for, and landlords they're reticent to loosen anything, and it becomes a really important
Right.
topic for us. So
And for good reason, because most landlords have a mortgage loan, and if you've got obligation to pay rent to them, they've got an obligation to take their mortgage payments. They're counting on the cash. I mean, that's kind of the economics of the whole thing. One other point before we leave this topic that I think is very often overlooked by tenants is the maintenance, repair, and replacement obligations that are in the lease. Whose responsibility is it going to be if the roof starts leaking? Who's going to have to repair it? What if a new roof is needed? Capital type expenditures. Whose responsibility is that going to be? Simple things like there's a plumbing leak, and it comes through the drywall, and these major repairs that have to be done. Electrical, fiber optic cabling, if it fails, all kinds of things. Who is it on? Is it on the tenant or on the landlord? It can go both ways. A lot of times it depends on the rent you're paying. What exactly are you paying for? The kind of thing. But that's something that's often overlooked, and you don't really realize what a problem that can be until the roof starts to leak, or the lights won't turn on, or there's water running through the drywall. Who's going to have to pay for these things?
that is a good one, because while the previous topics are usually contained in a provision, this is one where, and I'm not suggesting that it's by design necessarily, but you'll find exceptions and superseding events and references, and you're having to go back and forth throughout a lease document to really understand comprehensively, at the end of the day, what am I responsible for? And so again, it's why it's so important to have the right type of counsel and somebody who knows what they're doing.
And these things can really add up. If you have a standalone building with a parking lot, if you got cracks, things become a trip hazard. Who's paying for the insurance? Who's got to plow the snow or make sure it's plowed and make sure everything is salted correctly, so that you don't have ice and people slipping and all of these things.
There's another one that comes up every so often with us, and it's just a typical, use provision and what the doc is actually allowed to do. And this a lot of times a general dentist, they will dabble into orthodontics, or they will dabble into endodontics, and a specialist needs to, likely are not going to, dabble in the same in the same direction and do general dentistry, but they also need to know that they also want to have some protections, or they're inheriting a bunch of non-competes from previous tenants, or inside of like a retail situation, or maybe medical office building, where the landlord was trying to protect their tenants. Sometimes it turns into a rat's nest.
Yeah, and we not only the anti-competitive type clauses. If you're in a shopping center, you want to be the dentist and the only dentist in that shopping center. So clauses are necessary to make sure that occurs. But you don't see this a lot any longer. But we used to, where tobacco, candy, store, things that are sort of incompatible with a dentistry practice. You don't want certain things right next door. Marijuana distributorships. I mean, that's a big one these days. A lot of businesses don't want them in, a same multi-tenant kind of building, especially the, single-story shopping center with, that all share a parking lot. So yeah, we also think about those things, and you got to do your due diligence, and the good news is you can just kind of look around and see who the tenants currently are. But you may want to ask questions in due diligence about what are the terms of these other leases, and what are the chances that these places are going to renew if they're coming up. And if you don't want certain types of establishments right next door to you or across the parking lot from you, then you only have one opportunity to try and get those.
Yeah, we I guess it probably exists less in the dental space, but we see it in other spaces like the veterinary space, where a big, only so much of your business revenue can be generated in the retail, selling pet food, for example, because there's a big box store that happens to do the same. And although we do see it sometimes, not so much with other tenants, with businesses that are incompatible necessarily, other dentists themselves or specialists who, again, are performing, there are use restrictions where X number of dollars of revenue every year can't come from certain, and we're drawing from personal experience here, but all of a sudden you need to reconsider your business model and understand if those restrictions are acceptable to you or not, and trying to anticipate your growth, expanding services and so forth. So it's uncommon, but it can be tricky nevertheless.
Right.
Before we move on, let's talk about personal guarantees. I mean, that's probably one of the scariest parts, but it's one of those clauses that likely you're going to have to confront and deal with head on and come to terms with, because a lot of times inside of these leases you're getting the equivalent of maybe 8 months free, or some construction time plus a little bit of additional free rent, plus maybe $40 or $50 or even $60 per square foot of tenant improvement dollars. And so, it is a partnership. I mean, you are a partner with your landlord in your facility, and they need to be protected. And you want to, I've seen situations where sometimes with a more established dentist, they could, after several years of paying on time and no defaults, maybe the personal guarantee could burn down. But that's few and you don't normally see that. And also in Michigan, I don't see good guy guarantees either. What's your experience, Dan?
Well, I think it, like a covenant not to compete, it comes down to what is reasonable under the circumstances. I mean, if you are a young dentist, you're buying your first practice, you've been employed for a number of years, but you've never been a business owner before, probably very reasonable for a landlord to expect a personal guarantee. It's a brand new business to you. You don't have any established financial statements to put in front of anybody to show that you really know what you're doing, you've done this before, kind of thing. I just, within the last couple of weeks, have been working with a dentist client that has an established practice. 36 years this practice has been in operation. Very successful, has always leased space, has never missed a payment, is contemplating moving to new space. We get a lease from that potential new landlord, and not only was a personal guarantee being asked for, but there was also a security deposit provision in it. And the monthly rent was going to be $30,000 some dollars. I mean, who in their right mind is going to let someone hold 30 some thousand dollars of their money in interest free indefinitely? We were in the first turnaround of the lease back to them. I took out all those provisions, and in the email that I sent with it, I said, you're not dealing with a college student here or a new dental graduate. This is an established business that's moving from point A to point B, and we gave them financials to back that up. There simply was wholly unreasonable to ask for a guarantee or a security deposit in that context. But brand new dentist going in the same, probably would just say, look, this is the way it's got to be. It won't last forever, and you can talk about it being terminated. Maybe after 5 years, if there's been no default, or something, like address it with things like.
We don't make a habit of portraying landlords as human or sympathizing with them as we work on the other side of the deal, of course. But often we are having a conversation, setting expectations for our clients. And the guarantee is one of those regular conversations we have where, on one hand, we're working with you to soften the scope and severity of the document itself, but setting the expectation for a client that it's important and explaining why, and the landlord's perspective is really, in this case, what we're trying to get them to understand. And a lot of it's just optics, right? You take out a credit card and you sign off on it, and you're personally guaranteeing that you're going to pay that money back, and you don't think twice about it. So yeah, it's
Very true.
it's always a difficult conversation, but we try to make it a little bit easier. Any other lease points that we should be talking about and shedding light on for our doctors out there?
Only the not so much the text of the lease itself, but I think due diligence when you're considering any space is extremely important. And we talk at the outset about assembling a team. In this context, that team may include an architect, an electrician, plumber. You want people to come in and do a thorough inspection and make sure you have an honest third-party opinion about the plumbing, the electrical, whether the HVAC is going to be adequate, especially if you're leasing space that has not been a dental office before. You're going to turn it into a dental office. It may not at all be configured the right way. You may be knocking down the walls and moving things around. Are you going to have adequate airflow when you reconfigure the walls, and all of these things? You don't want any surprises. You want to know all these things up front when you're negotiating the tenant improvement. Know exactly what you're getting into, what plumbing is going to have to be moved from point A to point B, and all of those things.
Those are all great points, and we agreed. I think building a team, we often talk about the fact that we are transactional real estate brokers that have chosen to specialize in working with dentists and independent doctors. The equal or even greater value is building a team around them of professionals who are going to help today and long term into their future. So, again, I can't agree more with the idea of building around our doctors.
Yeah, no, the teams that we build actually are quite substantial because a lot of times our clients will meet multiple lenders, demographics companies, marketing companies. They ancillary to their business. I mean, they use some of the big equipment suppliers and equipment reps, which they're buying, their equipment from and consumables from, in addition to the contractors and the more, I guess, white collar folks like yourself and CPAs. And so it really takes a big group, a strong team to kind of ensure a successful successful transaction, because there's just too much money at stake for it to, because if it goes sideways, you can't, unfortunately, we haven't figured out how to go back in time yet. When that happens, maybe we'll be able to make some mistakes, or maybe
two other things very quickly that just kind of popped into my head. Parking and signage should not be taken for granted. How much parking do you need? And again, it's one thing if the space has already been used as a dental office, you can kind of you what the traffic's going to be like, and if you have enough. Coming in as first dental practice in a spot, how many parking spaces are you actually getting? And are they yours exclusively? Are you sharing them with other tenants? All things that you need to know ahead of time. Signage A lot of leases severely restrict the type of signage that you're able to use. If it's a unit within a building, there may be common signage, and you may just get your pro rata uh, square feet on a common sign out at the curb, and there may be a prohibition on any other signs. You're not going to be able to put something on the building necessarily. And even if the lease allows you or doesn't prohibit you to do it, what is the zoning that is applicable to the building say about signage and about parking? You got to make sure that your use is permitted by all governmental laws and regulations as well as.
I'm going
Yeah.
to add one more thing to that and say, when it comes to parking, because you're absolutely right, there are two considerations for parking, or two different values. One is, what does the ordinance require to comply for this use for dentistry? But that box has to be checked, but it's usually not nearly enough for the practical need, which is a lot greater. And so, understanding both of those ideas is something that we're looking at on every project early. Okay, so talk to us about some of the happier stuff here, like we promised. So what's the greatest compliment, or share a compliment that you've received that people would like to hear about?
Well, I think the greatest compliment a lawyer, a broker, an accountant, anybody could get from a client is when they call you back the next time something comes up and they want your advice. They want to know what you think about the next step for them. I think that's the greatest compliment that any client can give you. And it means you did something right first. You go from sort of being the hired gun, if you will, to being a trusted advisor. There's a big difference between the two, and striving to be the trusted advisor, earning that with client, having that kind of a relationship with somebody is certainly the most rewarding thing, or the greatest compliment I think any client can get. Probably the most satisfying experience for me professionally in the dentistry realm happened just earlier this year. There was a dentist 20 some years ago, right out of dental school. I reviewed his employment agreements, actually him and his wife, they've always worked together. Reviewed employment agreements for them. When they were ready to buy the practice from that employer, they came back. I represented them. We bought the practice. There are a number of other things in between that went on. And then just this year, they sold the practice and retired. And they called again. And so it's the complete life cycle of this practice with these two people. I guess it tells you how old I am, that been around long enough for all that to occur. But that's the most, I think, satisfying, rewarding thing is when you become that trusted advisor and things work out for people. And there are lots of things that went wrong for them along the way. I mean, it's just nothing's ever perfect forever for anybody. But that was very, very satisfying, very, very.
That's a great story. It's really awesome for things to have come full circle and have been with them at so many important milestones in their career. And it must, for us, a lot of times, we'll do a deal with our client and we try to stay in touch, but we probably won't be too active with another requirement for theirs unless they need to expand or they need to open up another location because they're signing a 10 year lease. We're not even getting on the move again for another 8.5 or 9 years a lot of times.
Right.
So that's really cool. We're kind of running up on an hour here, so we really appreciate your time. Is there any last key pieces of advice you would want to offer a younger dentist who is at the stage of thinking about opening up a practice?
No, I would just go back to where we started with the team. Make sure you assemble your team and that you use them and involve them. I think that's the best advice I can give for young people starting out.
Awesome. Well, Dan, we really appreciate your time. You've given us a lot of great insight and insider knowledge from the legal point of view, and we look forward to maybe having you on here again in the future. But we're going to wrap it up. Thank you so much.
All right. You're very welcome.
Thanks, Dan.